It's Saturday at the annual spring meeting of the American Bankruptcy Institute. I am Bill Rochelle, ABI's editor-at-large. It's about time we had a little ethics credit for you folks, so to that end, we have this morning Mary Walrath.
Good morning.
Bankruptcy judge in Delaware since 1998.
That's right.
Long time to be in the same place.
Yep.
Must be a good job, I guess.
It's a great job. A great job.
Well, Judge Walrath is going to talk to us a bit about ethics this morning. And my question to you, Judge Walrath, is how is it that ethics issues typically come to you?
Well, Bill, the court does not know what's going on unless somebody brings it to the court's attention. And that's typically by filing either an objection to somebody's fee application or a motion to disqualify counsel or a professional. We are not involved in the day-to-day happenings of a bankruptcy case, the administration, and certainly we're not involved in the formation of creditors' committees. So we often don't know whether people are stepping over the line ethically or not unless somebody brings the issue to our attention. And so I guess I've been deemed the ethics guru because I finally had to write an opinion on some of these issues when it was brought to my attention.
Well, that was a doozy, the Universal Builders case. I remember when I read that opinion, it really set me on my ear and thought it would have a major effect on bankruptcy practice. So tell us a little bit about that mess and how it happened.
Well, it was an issue that was raised regarding the formation of a creditors committee. And apparently one of the law firms had a relationship with a Chinese interpreter. And in cases where there were foreign creditors, Asian creditors, the interpreter would contact the creditors and suggest that they be on the committee when they got a solicitation from the U.S. Trustee's office about being on a committee, that they could serve on the committee, and that they should hire this specific law firm, and that he would act as their interpreter and proxy. And when he had rounded up a number of creditors in the top 20, the law firm got hired, and then the law firm would file an application to have the interpreter hired as a professional on the case because 3 or 4 members of the committee were Asian-speaking, Chinese-speaking creditors and needed an interpreter. So it was a tit for tat.
So what's wrong with that?
Well, we all know that lawyers cannot solicit clients with whom they have no business or prior professional relationship. And having somebody else do what you cannot ethically do is also a no-no under the Code of Professional Responsibility. So, and especially you can't do it for remuneration. You can't pay somebody yourself to be an ambulance chaser, and you certainly can't have the estate pay for them to do what is essentially getting you business.
Oh, gee, that would be a nice idea that the
Yes.
estate pays to get your job in the first place.
Paying the interpreter fees, yeah.
Yep, that's right.
Yep.
Well, situations that entail conflicts of interest. I mean,
Yes.
with computers these days, law firms ought to be able to know whether they have adverse or even non-adverse relationships with whomever, because the computer spits it out for you. So how is it that conflicts arise in bankruptcy cases?
Well, they do know they have relationships with different parties in the case, and especially in the large cases. You're not going to have a large law firm who's capable of handling the case that does not have some connections or relationships with the different parties in the case. There are literally tens of thousands of creditors, and somewhere on that list is going to be a creditor that your law firm, your mega law firm, has a relationship with, a prior client or even a current client in an unrelated matter. And so yes, it is possible to file a disclosure that includes those because your computer records will show that you have that relationship. Where it gets tricky, and the circuits have been very good at this, the Third Circuit has said a potential conflict is not disqualifying. It's only an actual conflict. And the actuality happens when that specific creditor is involved in an actual dispute with the estate, or wants to be a bidder for assets of the estate, or is sued for a preference and you're still representing that creditor. We've also been very easy, I think, in those situations in allowing for not the total disqualification of the law firm when that actual conflict arises, but allow that law firm to step back, not be involved in that conflict, and get what is called conflicts counsel to handle that. So I think these many connections and potential and actual conflicts can be handled. What happens is when people don't disclose, don't let the court know right up front that this issue has come up and it has now become not a potential conflict, but an actual conflict. Or when what you list is a potential conflict is really an actual conflict. For example, I list that my law firm has a relationship with one of the banks in the case, without disclosing that I can never sue that bank, and I'm going to do everything within my power to be sure that that bank does not get sued in this case. Now we're talking about an actual conflict that has not been disclosed to the court.
Well, you know, sometimes when these conflicts arise and the judges have to, unfortunately, shall we say, discipline somebody, people will say that the court's overreacting.
Wow.
Do you see it that way or not?
We are human, and it is hard not to overreact when some extreme example of a conflict is brought to your attention a year after the fact. And now the U.S. trustee is asking to disgorge fees in the millions of dollars. And the law firm or professional is otherwise trying to defend not having disclosed and having really conducted themselves in a way that is not ethical.
Yeah.
And yes, sometimes we do overreact. In baby judges class, we're taught to take a deep breath, maybe take a 5-minute recess so that you don't overreact. But it's human nature, and judges get pretty angry when people don't follow the rules.
And by the way, when there are these, let's call them ethical lapses,
Yeah.
is it usually because of a systemic failure within a law firm, or is it usually one person's mistake?
It's, in my experience, it is rarely a systemic failure, because all of the law firms know they have computerized systems, they have an ethics partner, they have set up the systems to try and prevent these situations. And really, where you have problems, it's the rogue lawyer or the rogue professional that is doing something wrong, and quite frankly is not telling their law firm. Mm-hmm. And I'm sure that the law firm, the ethics partner at the law firm, had the same explosion that the judge does in court privately with that partner when they find out what has been going on.
Well, I guess you could say that's a career-limiting gesture when you
Yes.
when you get yourself in one of those
in those
messes.
situations. And it is. And these situations are very difficult. They're embarrassing. The judge hates to be the bad guy, hates to be the parent. But it's our job to make sure that the rules are followed.
Yeah.
And as difficult as it is, we have to write the opinions. And hopefully, by writing the universal builder's opinion, I felt it was important to get it in writing to serve as a warning to others. And those who are acting professionally, who see that others are breaking the rules, should be just as angry as the judge that they are breaking the rules.
Well, Judge Walrath, your universal builder's opinion certainly changed bankruptcy practice throughout the whole country, not just Delaware, that's for sure.
I hope for the better.
Well, we thank you very much, and hope you have another, nearly 20 years on the bench.
If I live so long, I will.
God bless. Thank you.
Thank you.